The overturning of Roe v. Wade was always destined to be a political mess, even if it is a necessary one. No matter how it happened, it was always going to produce incoherent screeching from people who did not read this decision and have never read Roe and have never read any of the cases preceding Roe that Roe claims to be based on. So no matter how clean the reasoning of the opinion to do it, no matter how compelling the legal argument, the true believers are loyal to the concept of abortion itself, not to the Constitution or the process to decide that issue. And so any opinion counter to that highest value was always destined to be met with hostility. But it certainly didn't have to be this messy, though. There is a terrible irony that we're replacing one stain on the Supreme Court's history with a brand new stain on the Supreme Court's history. Assuming this report is correct and Roe is destined to fall, we are replacing one of the court's worst all-time decisions with one of the court's worst all-time betrayals, the leaking of a draft opinion. According to Politico's story releasing the draft, a leak like this has never happened in the modern history of the Supreme Court. Other stories note that certain details of some cases, including the original Roe v. Wade decision actually, have leaked to the press before official decision publication, but in those cases, the actual draft opinion wasn't published early as it was in this case. This is effectively a never event, and we don't know who did this, but it's fair to surmise it's for the same reasons that the activists won't read the actual opinion anyway. To whoever did this, the outcome is more important than the process. And so even if the entire legal system is a casualty of their outrage, well, so be it. And that is not an exaggeration. Consider the severity of the consequences. It's also fair to infer that the intent of the leak is to intimidate justices, to get them to see the outrage and then to change their minds in fear of the outrage. And even if they do withstand that fear, the trust between the justices and their offices will now be severely damaged. How is a justice supposed to write and vote on opinions honestly, knowing that his colleague may take that information to the press tomorrow to get him? If we all claim to agree that politics must stay out of the court and the court must remain a house of the law, then we all should agree that this sort of leaking has to be investigated and ended because it necessarily injects politics into the court. The purpose of the leak is to politicize. It's not immediately clear that the leaker actually broke the law, at least purely by the leak itself, though depending on how the information was obtained, there could be a computer hacking crime or some other tangential crime. But criminal or not, the court is well within its rights to police its own, to find out who did this, and to hold that person accountable to the maximum extent possible, as the Chief Justice is now promising to do, which also creates an interesting political dilemma for the president. Of course, Biden has advertised himself as the man of unity, the man of loyalty to our institutions and systems over partisan political differences. Well, not only rule of law principle, but his own branding should compel him to deliver a condemnation of this leaker and a pledge to help find this leaker in pursuit of accountability. But of course, if he does, he'll be viewed as a traitor on a priority progressive issue. So what wins? His commitment to unity and to principle, or his bending over to fringe progressive activists? And I think we all know the answer, so I guess this dilemma isn't actually all that interesting after all. Before I could even finish this video, Biden had already caved to the politics.
The idea that we're going to make a judgment that is going to say that no one can make the judgment to choose to abort a child based on a decision by the Supreme Court, I think goes way overboard.
While also getting the politics totally wrong, of course. The court's pending opinion does not say that nobody gets a decision on abortion. It says the decision is properly reserved to the states and to the people, not the court by made-up decree. Leave it to Joe to get the point exactly backward, and it's pretty important that we get that point right. It's not to diminish the importance of the other points, the moral weight of the abortion question itself, the importance of institutional integrity and a president who will stand up for it even when his politics lose the day. But the point that Joe misses from a legal perspective is actually the most important one. And unless we pay attention, we might miss it too. It becomes a casualty all but silenced in the rest of this noise. Roe v. Wade is among the worst decisions in the court's history as a matter of law, not as a matter of your personal abortion opinion, stuff you like doesn't make a Supreme Court decision good. Fidelity to the law and the Constitution do, and there is no coherent legal argument in favor of Roe. It was made up nonsense then. It remains made up nonsense today. And this leaked opinion from Alito explaining that point is excellent and well written. So of course, it will not be well read nor well publicized. Instead, we'll hear it characterized as some sort of anti-abortion or anti-women rant, but of course it has nothing to do with the wisdom or the folly of abortion policy. It has everything to do with who holds the right to make those decisions as a matter of law, not as a matter of the personal preferences of the bench. The reason to know this leak is authentic and not some fake is not just because the Chief Justice John Roberts has now confirmed its authenticity. It's because it's an argument so thorough and thoughtful using language Alito has previously used in a way that only he could write it. The opinion is quite long. It's nearly 70 pages of argument, 30 more of appendix material. It is very clear reading it that Alito has been rubbing his hands for a very long time in anticipation of this opportunity, but because it's one that he takes seriously. So it's an argument that he makes comprehensively. And he could have been much more simple and just written, abortion isn't in the Constitution, lol, GTFO. But he didn't. Instead, he gave the pro-Roe side as much credit as possible, though he didn't have to. He steel-manned their case and still demolished it in crafting a decision that is all but inarguable legally. His argument should be credited for its good faith and its intellectual honesty and rigor, but of course it won't be. It'll just be smeared as some sort of ideological attack without any textual reference, of course. So let's give his text that proper reference and consider his argument. He deserves that consideration as he extends it to others, and any honest opinion about whether he's right or wrong requires as much anyway. Alito begins with how we evaluate what are and are not constitutional rights. Of course, there are the obvious enumerated ones, the ones explicitly mentioned in the document, your First Amendment speech rights, for example. And then there are unenumerated or implied rights. Think your right to a presumption of innocence. It's not explicitly stated in the Constitution, but a concept of due process in a court of law requires it. If we presume you guilty, the entire concept of due process is reversed. Nobody argues that abortion is in the Constitution's text because it isn't. So the argument is that abortion is an implied right. Alito doesn't necessarily have to entertain this argument, but he does, and he thoroughly explains why abortion is not, in fact, constitutionally implied. First, because Roe's right to an abortion is not any sort of direct implication from the text itself. It's an implication of an implication, and a weak one at that. Roe claims the implied abortion right is derived from the implied privacy right, without explaining, even if we grant that privacy is an implied theme of several constitutional provisions, how abortion fits into that concept any more than murder or other crimes do. And of course, Roe didn't stop at just making some double implied inference on an abortion right. It prescribed an entirely made-up regulatory framework, too. At the time, it was the trimester rule. States could not regulate abortion in the first trimester. They could in the third, and there was a mess of this but not that allowed in the second. Bizarre specifics which certainly have no basis in the constitutional text, achieved only by several leaps away from it. Even if we grant that rights exist by implication, Roe goes well beyond that and says specific regulatory framework exists by implication. Of implication, there has to be some sort of limitation on such reasoning. And there is. Not just what Alito says is the limitation, but what Supreme Court precedent does. For all this talk of loyalty to precedent, Alito is loyal to precedent. We have objective, established criteria to define what implied rights are. In addition to a textual basis in the Constitution, implied rights are deeply rooted in American history and tradition and are fundamental to our scheme of ordered liberty. Again, according to Supreme Court precedent, not according to Alito. In the case of abortion, the history and tradition isn't just absent, it's the opposite, actually. The history and tradition is of criminalizing it. At the time of Roe's decision in 1973, abortion was illegal in 30 states in all situations but for threat to life of the mother. If you want more history than that, In 1868, when the 14th Amendment, the alleged basis for this right, was ratified, 3/4 of states criminalized abortion, as did the territories. If you want more history than that, abortion was criminalized in colonial America. If you want more history than that, abortion was criminalized under English law dating back to the 1300s, and nobody argues this point. Not the abortion clinic bringing this case, not the briefs submitted in their support. Nobody can show that abortion has been a historical right. And if you don't have that history, you don't have the evidence that precedent demands to find an implied right in the Constitution. Or at least you don't have one of the ways, but recall, there is another. Perhaps you want to make the argument that abortion is a right fundamental to our constitutional scheme of ordered liberty, as precedent allows. Well, one, it's hard to make that argument without any supporting history. Did ordered liberty not exist prior to 1973? Regardless, to Alito's argument, what does our system of ordered liberty mean if not for the rights of the people in each state to decide contentious issues and balance competing interests for themselves? How does ordered liberty mean 9 unelected justices get to usurp power from the people and seize it for themselves? Okay, but what about all the other rights, the critics may counter? If you erase this right, what stops you from erasing all the other implied rights? Alito considers this concern too, though again, he doesn't have to. He does it to be thorough. As discussed, valid implied rights meet 3 criteria. They have a textual basis. They have a historical tradition. They have some fundamental function in our system of ordered liberty. Abortion does not meet these criteria, but abortion is also unique in another way. Alito notes, by Roe and Casey's own descriptions, it is the termination of life. It carries with it that inherent weight and that inherent threat of permanent injustice. Injustice for your marriage rights can be reversed. Injustice for your procreation rights can be reversed. Injustice that costs you your life cannot. You're gone. For these reasons, Alito states explicitly, this opinion overrules the supposed constitutional right to an abortion only and no other right. Oh, but it's precedent. That's the last stand of the activists. You can't overturn Roe because it's established and settled and it's history. Well, one, we actually have more post-14th Amendment history in which abortion was criminalized, not legalized. But 2, and more importantly, surely precedent isn't locked in forever because bad decisions do get made. And Alito again gives this point a full good faith precedent-based argument too. If we agree that it was correct to overturn Plessy versus Ferguson and the separate but equal doctrine, among other bad precedents, surely there are standards for when overturning precedent is appropriate and correct. And again, according to precedent, not according to Alito. Alito is following precedent in justifying overturning Roe. Alito outlines 5 justifying factors used in prior decisions to overturn cases. The nature of the error is the first consideration. What anti-constitutional consequences has the case created? In Plessy, it was denying equal protection. In Roe, it's revoking a question of profound moral and social importance from the people. Roe short-circuited the democratic process by closing it to a large number of Americans who dissented. The quality of the reasoning is the second consideration. As we've mentioned, it's reasoning with no basis in text, history, or precedent, but it fails even basic logical standards. Roe and Casey established a viability standard in which the child has a right to life once it's viable, or could survive outside of the womb, but that standard isn't even consistent. Viability varies by child. It varies by mother. It varies by technology and proximity to that technology. It's a standard that changes every day and is different for different people, which means it is no standard at all. And on the remaining considerations, Roe fits precedent-established criteria for overturning a case as well. On workability, as in whether the standard can be applied in a consistent and predictable manner, Roe and Casey's standards aren't. Viability varies, and the standard Casey established to prohibit undue burdens against obtaining an abortion is inherently standardless, as Scalia wrote, because the court gave no definition to what is undue. It is a completely subjective judgment. Indeed, it was a subjective judgment among the justices on that court at the time. In that case, Justice Stevens thought the waiting period at issue was undue and the rest of the justices did not, uncompromising the court's other decisions. Another qualifier to overturn based on precedent, Roe undid the formerly strict standard for constitutional challenges and created a court that can simply invent outcomes it likes rather than the outcomes the law commands. And lastly, there are no reliance interests that precedent demands be considered before overturning. By its nature, abortion is not a planned activity, or at least Alito concludes that by perhaps giving these people too much credit. What remains of their sanity might actually rely on their lust for an abortion, but to Alito's point, that's really more of a them problem than a Supreme Court problem. And Alito's still not done. You have straws to grasp, and he has a gavel to swing, but he does the nice thing by listening and answering in good faith anyway. But women are going to be subjugated now, we'll surely hear screeched from under the Handmaid's Tale costumes. How? In Mississippi, the state that passed the abortion law in this case, women outvoted men by a 10% margin in 2020. It's a trend that's true nationally, too. Women outpace men in both voter registration and turnout. Unless that decades-long trend suddenly changes, whatever reaction happens to this case will be the result of women's political power, not the lack of it. Well, what about institutional integrity, the critics may ask? Hasn't the court just undermined its own trust? Well, how does the court earn trust, Alito asks. The court earns trust with strong, constitutionally faithful opinions, not raw judicial power exercised at the expense of the people and their states. And that is a very long tour through a lot of details, I know, but the point is, Alito is not cramming down some ideologically driven dictates as he'll be accused of. He has listened carefully to all of the arguments, he has considered them, and he has explained the principles that compel the court to return this issue back to the people to decide. It's a completely considerate decision, not a dismissive one. Alito gave these activists far more kindness than the point and laugh that they deserve. But because Alito is so thorough, it can be difficult to summarize the substance of the argument briefly, so let's do that to understand it and to invite the rebuttals that won't come because they're all but impossible to make with any fidelity to the law. Number one, abortion is not an enumerated constitutional right. Number two, abortion does not meet the established criteria for identifying rights implied in the Constitution, those being a textual basis, a history and tradition of the right, and the right being fundamental to our scheme of ordered liberty. Number three, therefore, the Constitution is silent on the issue, and where the Constitution is silent, by the explicit constitutional requirement of the 10th Amendment, the issue is properly reserved for the states and the people within them to decide. Screech all you want, but those pillars of Alito's argument are as bomb-proof, text and precedent-based as it gets. It's why we'll hear little of an actual argument against it. Instead, we'll just get generic smears and mischaracterizations without actual reference. They don't read it because they don't care to. As simple and solid as Alito's argument is, theirs is much simpler. I like abortion, therefore abortion is a constitutional right because stuff I like is more important than the rule of law. Good luck maintaining a country according to such subjective, standardless nonsense. The maintenance of the country depends on the maintenance of the states and the proper reservation of power to them. Assuming this decision is actually finalized in the near future, and Roe is actually overturned, it will be a big win for that constitutional principle. And better yet, it's a big win for the states in another big way. Maybe now these people will finally stop moving to ours. California is doing their damnedest to keep them. Please come back. We'll pay your expenses to be an abortion tourist in our rotting, God-forsaken state. Just give it a couple weeks, and they'll be offering an all-inclusive Disneyland abortion package. Just watch. And if any of that is even remotely appealing to you, please take that deal. We just can't compete with that sort of extravagance here in flyover country. We're just a bunch of simpleton rubes who cherish our right not to. Thanks as always for listening and for supporting this channel. Always appreciate that thoughtful discussion down below, and especially over on Minds, that is at ML Christiansen. You're always welcome to coming out and chatting my live streams. Those are linked down in the description. Looking forward to it. Goodbye.